Hi everyone, grab a drink and settle in. Welcome to the Wheels and Spills podcast, where we sip cocktails and unpack the most fascinating estate disputes behind the court judgments. The podcast is about real people, real family disputes, and the wills that have sparked them. Now, to help me spill the story behind our next case, I have Bree Ridgeway. Bree is a barrister who has a commercial and common law practice focusing on wills and estates. She appears regularly in the trust and equity and probate and testators family maintenance lists and also the guardianship list at VCAT. Bree was named the recommended junior counsel of the Doyle's Guide to Leading Wills and Estates Litigation Barristers. Welcome, Bree.
Thank you for that introduction. And thank you for having me.
That's all right. So tell us, what case are we unpacking today?
So today we're going to have a look at Drousiotou, which was a decision handed down earlier in 2026 that was a prima facie case determination of what we would describe as contested probate proceedings. So someone saying that the will that the executor is trying to probate is not in fact a valid will and ought not be probated.
Before we dive in, I'll provide a brief summary of the background to the case. The deceased died on the 5th of October 2024. At the date of his death, Terry had predeceased him, having passed away in 2017. The deceased had been in a relationship with Terry for 32 years. The deceased had no children. He was survived by his two sisters, his niece and his nephews. He left a will dated 15th of April 2009. He appointed Terry as the executor and his solicitor was his substitute executor. I'll refer to this will as his 2009 will. Now, in this will, he left his entire estate to Terry, and in the event that Terry had predeceased him, his estate was going to be distributed between 5 charities. His solicitor, as the substitute executor, applied for grant of probate of the 2009 will. The deceased niece and nephews, who were secondary beneficiaries in a previous will, lodged a caveat on the basis that the deceased lacked testamentary capacity at the time he made the 2009 will. Now, by lodging a caveat, this prevented the court from granting a probate of the 2009 will. It's basically a legal pause button that stops the administration of the estate until the court can address the concerns raised by the person who's filed the caveat. Now, in this case, it was the niece and nephews of the deceased. The solicitor executor sought a prima facie case hearing. Now, from those who've listened to my previous podcast, we've discussed this concept prima facie case. But for our new listeners, Bree, can you please explain what is a prima facie case hearing?
So prima facie, or the phrase prima facie is found all over the law, but it's got a really specific meaning in the context of contested probate. So when someone ordinarily applies for probate, they are the plaintiff in an application to get a grant. If someone comes along and says, I don't think that person should get a grant either because the will's invalid or because they're not an appropriate executor, that person is a caveator. Now, the caveator is not actually a party to the proceeding until such time as they're joined, and then they become a defendant. A prima facie case hearing is where the plaintiff, so the executor, says, well, I've read your grounds of objection and I don't think that there's enough in them to impugn the will or impugn the nomination of the executor. And accordingly, I think that the objection should be essentially summarily dismissed at an early stage before there's been the opportunity to put on evidence or put on, any sort of substantive material or do discovery. So it's very similar to a summary judgment application describe it as a regular civil case, but it's quite specific to the probate jurisdiction, and it happens before the caveator has been joined, and so before they've had the chance really to do discovery and get access to things like the will file or the medical records. So it's a pretty unique kind of a hearing. It can be a really cost-effective way of getting rid of a nonsense claim, or it can be sort of an extra costly step.
Yeah, we'll go through that and we'll have a look at their objection. So as mentioned, the niece and nephews objected to the 2009 will being admitted to probate on the basis that they believe the deceased lacked testamentary capacity when he made that 2009 will. Bree, this is a common objection we see. Most clients seeking to lodge a caveat do it on the basis of their concern that the will maker didn't have capacity at the time. However, we know they're required to particularise the grounds of objection, and the onus is on them to establish a prima facie case. As we know, it's more than mere suspicion, isn't it? And it's not just speculation. That's not sufficient. There must be proper grounds or evidence to support this challenge. Bree, can you take us through what's the bar for testamentary capacity?
So testamentary capacity is a legal test. It's not just a medical test. So it's not something, unless you've got a very dire medical condition, that can usually just be established based on medical evidence. It's essentially answering the question of when does the law say it's appropriate to step in and deprive someone of their testamentary freedom. And the test that is that we use to establish that comes from Banks and Goodfellow, which is an age-old test case for testamentary capacity.
We all know this as
everyone is incredibly familiar with, but it requires specific things of a testator in order for them to have capacity. The first of which is they need to be able to understand that what they're doing is a will. So they need to understand the nature and the effect of the document, so that it's a will as opposed to, for example, an inter vivos gift or a contract or, some other form of document. They need to have an understanding about what comprises their estate. So in some cases that will be a really straightforward test to answer. They might say, well, I've got a house and I've got some super, and I've got a bank account. In other cases they might, if they've got a complicated corporate structure that's got several companies and many investment properties, it might be a bit more difficult for them to have that understanding. Thirdly, they've got to understand the claims upon which, the claims that might come upon their estate. So the people who they would ordinarily be considered to have to make provision for, or not if there are good reasons not to. And then lastly, they need to not be suffering from, and the text of the Banks and Goodfellow case is from the 1870s. So it is reflective of the language of that time, and it is that they need to not be suffering from any insane delusions that would cause the miscarriage of their testamentary obligation. So that's where we get the word delusions, which is used throughout this particular case, but often it's something of an inflammatory word to be broaching with clients who are coming across it, even though it does have a relatively particular legal meaning here.
Yep. Well, that's good to know what the sort of bar is for testamentary capacity, because clients do often come to us and say, well, mum didn't have capacity, dad didn't have capacity, and often we have to explain to clients what the court looks at. In this case, the judge also made reference, there's also this presumption that a will is valid where a will is duly executed and is rational on its face. So the court observed that the deceased will was rational on its face, as the deceased left his entire estate to his partner of 32 years, and he's the only person really he had a moral duty owed to. The court also observed this was rational on its face, as the charities in the will, the deceased had admired and supported them for a long time. The court did not consider that it was irrational for the deceased to exclude his sisters, niece and nephews. There's no moral obligation to provide for them, and the deceased was not obliged to provide an explanation. So in addition, the court also said the will was prepared by an experienced solicitor who the deceased had a pre-existing association. I think that's important. It's not like the deceased went down the road, met a new solicitor and they just drew up a will. So it's a solicitor he's had a relationship with and a solicitor who knows him. The will was also signed and witnessed at the solicitor's office. The other interesting thing to note is that the will was also accompanied by a letter written by the deceased, which he explains the rationale for gifting his entire estate to Terry and to the charities. Bree, can you take us through what he wrote in this letter?
I will. I was thinking I'd read it out.
Yes, perfect.
But first, I just wanted to make the observation that there is a really big difference in the way the court looks at wills that have been drafted by particularly experienced estate solicitors versus a will that might be homemade, for example, and wills that are rational on their face as opposed to irrational on their face. And where you've got a solicitor who's got a long-standing relationship with a particular client, where that solicitor has, done their due diligence, and where the will does not do anything particularly crazy, it doesn't, disinherit a spouse and children, for example, in favour of a friend that the deceased has made very recently, the court, generally speaking, will be much more reluctant to set a duly executed rational will aside than, for example, where you don't have the benefit of the involvement of an experienced estate planner, or where you've got something which really does seem to be quite a radical departure from previous wills of the testator, or from what one might reasonably expect their testamentary intentions to be. In this particular case, there was a letter that was left with the deceased's will, and I think it's particularly interesting in the context of this case because letters are really common when you're looking at Part 4 claims. What were the reasons for that the deceased had for cutting out this particular person? Oh, it's handy. They've articulated those in a letter that they kept with their will.
Clients love it.
And so there can be a lot of utility in terms of when you're sort of trying to preempt a Part 4 claim in explaining what your reasons are, because your client's not going to be around to give evidence in the witness box at the time the will is challenged. It's quite unusual to have a letter of that nature in the context of a testamentary capacity dispute, because the letter isn't directed at the question of capacity. It's directed at the intentions. This particular letter is also kind of interesting. I'll just read it out and say what my comments are.
We can definitely discuss it because it does get talked about throughout the whole case.
Yeah. So he says in his letter, I'm addressing this letter to my executors, to the executors of my will, to clarify my reasons for distributing my estate in the way that I have. In the event of my partner Terence living beyond my death, I've directed that my whole estate should be given, devised and bequeathed to him. My reasons for doing that are that Terence and I have been mutually supportive, lifelong personal partners for a long period, a period of 32 years at the time of this statement. During that time, we've provided to each other all the personal, emotional, financial and other support that each one needed. No other person in my life has ever done this, and this is the reason for the nature of my will. And that phrase, no other person in my life has ever done this, was really seized upon by the caveators in their case. And I'll get to that in a bit. He says, I've excluded my two sisters from any benefit from my will for quite specific reasons. Both of my sisters have totally excluded me from their lives and those of their families since the year 2000. The reason for their doing so was the fact that I'm gay and share my life with a gay partner. Ever since that time, they've never invited me to their homes or family occasions, and in fact, I have not seen or spoken to either of them since the year 2000. If Terence should predecease me, I've directed that my estate should be equally divided between a number of specified charities. These are charities which Terence and I have admired and supported for a long time, and we've agreed that they would be worthy beneficiaries of our estate once we are both deceased. So this is a letter that's really directed at the question of a Part 4 claim, as opposed to a question of capacity.
Of capacity, correct.
If it had been directed at capacity, it would say potentially something like,
I'm of sound mind.
I'm
not on any medication.
It would say something like, I understand that what I've done is a will. This is my knowledge of what my estate comprises at the time. These are the people who I think I should make provision for, and these are my reasons for
they'll go through
doing
that
or not
test.
doing. It'd go straight through Banks and Goodfellow. And I've never actually seen a letter left by a deceased person that has done that, because usually they're directed at Part 4 rather than at establishing that they had capacity. But the fact of this letter and the fact that it has made this assertion, firstly, that no other person had supported him in the way that his partner did, and then secondly, that there's been this exclusion by the sisters, and I'd say very specifically sisters, not nieces and nephews, because the sisters weren't the caveators, the nieces and nephews were.
Nephews were, correct. I think we're going to dissect that a little bit, and I wanted you to read out that letter for our viewers, because I think it's helpful for them to understand what he actually wrote, because in this case, you're right, the niece and nephew really dived into that letter, and let's dissect it a bit, because they talk about that letter, and that's one part of their grounds of objection. So in their grounds of objection, they state that there was no basis in reality for the deceased to rationally believe that no one had ever provided him with personal, emotional, financial support. Now, they say this just wasn't true, because the deceased sister had in fact supported him when he was younger, and they expand on this by providing examples. They also rely on these facts to establish that the deceased was therefore delusional, there's that word again, that he was delusional when he made his will, that the delusion impacted his ability to exercise his testamentary power, and so he excluded his sisters and their families. So, Bree, how did the court respond to this?
Well, one of the things which it's pretty important to remember in the context of a prima facie case hearing is that the court is required to take the caveator's case at its highest. So They can't get into, an evidentiary dispute about the reliability of certain evidence or, whether or not evidence that's been deposed to in an affidavit is likely to be picked apart in cross-examination. They just have to take the evidence at its highest and see if that's the case, has a prima facie case been made out. And one of the things which was apparent with regard to the level of support contended was that they weren't really comparing apples to apples, they were comparing apples to oranges. So it may have been the case that the deceased sisters provided him with support when they were younger, when he was younger. But what he spoke of in the letter was a 32-year relationship with intermingled financial affairs, emotional support. And even if the plaintiff's evidence was going to be accepted that the sisters had provided support and that they had a loving relationship with him in his younger years, it wasn't delusional for the deceased not to equate that with the support that he'd received from a life partner.
Yep. Their other grounds of objection further state that there was no basis in reality for the deceased to rationally believe that the deceased sisters had totally excluded him from their lives and those of their family since the year 2000 due to the fact that he was gay and shared his life with a gay partner. Now again, the niece and nephew contend that this statement by the deceased was delusional because the family had accepted that he was gay. They go on to list examples in their affidavits to demonstrate how they accepted the deceased and Terry back in the 1980s. They say the family had been warm and friendly to Terry at family events. They say Terry and the deceased had always been invited to a number of family weddings and birthdays. They also contend that nothing happened in 2000 which would justify the deceased's statement that his sisters had excluded him from their lives. So did the court accept this, or what does the court have to say about this?
Well, that kind of evidence and the nature of that evidence is the kind of thing that you'd really expect to be the subject of cross-examination at trial and intense scrutiny at trial. But for the purposes of a prima facie case hearing, the court's got to accept it at its highest. Even that being the case, one of the things that came through on the Caviator's affidavit material was that they hadn't really had contact with him after the year 2000. I think there might have been one instance that's referred to in the judgment where he'd been invited to a wedding and he didn't attend or something along those lines. The court placed more weight on the fact that there hadn't really been any contact between the Caviators and the deceased in the 9 years leading up to when he did his will than the reason for the relationship breakdown. I'd be speculating, but I'd imagine that if the evidence had been that they maintained contact each week, for example, that might not have been as much of an issue for the court to get over. But on their own evidence, they had not maintained a relationship with him after 2000. And so the reason for that was not under as intense scrutiny as perhaps it could have been if the relationship was ongoing.
Yep. Now, the niece and nephews also contended, and they said this throughout their whole objection, they said the deceased suffered a mental illness, including bipolar disorder and depression, and that he'd been treated on medication and he had mental illness. They asserted that C showed symptoms of mental illness, particularly around after the year 2000, citing instances where they observed that he was paranoid and was making irrational decisions. But they couldn't provide any details or dates or instances when this had occurred. But to assist their assertion of this, they did rely on a report that's prepared by neuropsychologist Dr. Monica Williams. Now, that was dated 21st of February 2019. How did the court view this report? And did the report have any bearing on the deceased's testamentary capacity in 2009 at the time he made that will?
So the date difference is a real problem, and it's a situation that a lot of Caviators find themselves in, where they're at a sort of a forensic disadvantage in terms of if they haven't maintained a relationship or they haven't had access to the deceased person, they just don't have evidence to hand about what's going on with their medical affairs. They may well get that after discovery, but prima facie case hearings are not conducted, after discovery's taken place. And the 2019 report was ultimately not of a lot of significance to the court because the point in time at which testamentary capacity is assessed is 2009, so some 10 years earlier. And it just has and it was prepared for the purpose of a power of attorney hearing. I don't believe Dr. Williams was asked to assess testamentary capacity, and even in 2019, let alone opine on what capacity might have been some 10 years earlier before she saw him. So it wasn't of a lot of assistance. The reference within the report was to a self-reported history of mental illness, but it's quite well established that mental illness alone does not preclude someone from having testamentary capacity. You need to really be able to establish that link between whatever the mental illness happens to be and the carrying out of the drafting of a will and considering the claims and considering the estate. And if you can't draw that nexus, then the court's not going to take away the right of a mentally ill person to make their own will.
So really, when the court reviewed all the material, the court wasn't satisfied that deceased's 2009 will was untrue, irrational or delusional, and therefore the court was not satisfied that there was a case for investigation that he lacked testamentary capacity. The niece and nephews could not establish a prima facie case, and the caveat was dismissed. They were also ordered to pay the executor solicitor's legal costs incidental to the caveat, including the cost of the hearing. I want to highlight this important point. The court ordered the niece and nephews to pay the executor's costs. That meant they were liable not only for their own legal costs, but also the cost of the other side. I mean, this is a stark reminder of the real risk, really, for anyone considering lodging a caveat without a proper basis or a prima facie case. Bree, what are your takeaways from this case? And can you also tell me, do you think the letter in this case assisted at all? Because it was such a big issue in this case, and niece and nephews really drew upon that.
I mean, costs are always tricky in contested probate proceedings. If you're looking, for example, at a Part 4 and you've got a client who's got a decent enough claim, it's normally going to be a question of quantum rather than a question of is it something or nothing. Whereas with contested probate proceedings, you either get the will that you want or you get the will that you're stuck with, and there isn't a lot of black and white in terms of outcomes at the end of the day, and because of that the cost risk is particularly high. So if you roll the dice on a borderline caveat and you lose, then you'll end up with cost consequences. And that's something which I think perhaps, I mean, we've got to be mindful of costs in all of the proceedings that we're involved in, but I think it's particularly the case for contested probate proceedings. In relation to the letter, it's something that I've thought a lot about, because in this case, the letter did cause some problems, but it also solved some problems. And I think it was directed at solving a different problem than the one that it was ultimately confronted by. It was directed at the problem of a potential Part 4 claim brought by the sisters and potentially the nieces and nephews, or at least that's my reading of why you draft a letter like that. And nowadays, one of the first things you'd ask your clients is, well, are these people you're worried about bringing a claim, are they actually eligible people? Yes. Because if they're eligible persons, then there's potentially a lot of utility in drafting a letter setting out why you've done what you've done in the will. And that letter will be extremely probative evidence in a Part 4 claim if one is brought against the estate. If the response to the question is, well, no, they're my sisters and they're my nieces and nephews, then the advice that you're probably going to give, unless they could be a member of the household, is, well, they're not eligible, so just, you don't need to. That's based on what's the case in 2026. 2009 was well before that legislation was amended. So, drafting the will in 2009, the siblings and nieces and nephews definitely, could have brought a claim. And there was a real utility potentially in making sure that any claim would have evidence in it as to why he had excluded them to start with. So that's a bit of a vague answer, and I certainly wouldn't say don't leave a letter with your will explaining why you did it, even if you do end up fighting about the wording of it later in the later on in after you've died. But one of the things that the advice I would have given in 2009, advice I'd give in 2015, and advice I'd give in 2026 is be really mindful about what you put in the letter. And if there's anything which is, and I don't necessarily think this is the case here because we'll never know now that this matter won't proceed to trial. But there's a big difference between putting something in a letter that you can back up versus something that the other side can prove is demonstrably untrue. We'll never know in this case where it falls. But if you're thinking about leaving a letter, that's probably the main thing that I would have in mind is, are they eligible people? So do you need to be doing this? And secondly, be very careful about what you put in them.
Yeah, that's very good advice. My last question before we go, Bree, if we've got listeners out there who want to launch a caveat because they say mum didn't have capacity or dad didn't have capacity or my sister didn't have capacity, what as a bare minimum do you think sort of evidence they should have so they're not in a similar situation?
They need particulars, and they need particulars that are addressed towards the factors in Banks and Goodfellow if the assertion is a lack of capacity. It's not enough to say, I suspect that maybe my mum didn't have capacity.
Yes.
It's not enough, in my view, to simply assert that there was a diagnosis. The more information that you have, the better. Being able to point particularly to specific points in time at which the deceased might have been struggling to do things like, remember the names of her family members and that kind of a thing. If you've got evidence of that nature, those are the sorts of particulars you want to have in your grounds of objection. If it's looking very speculative, or you've got clients that are saying, but won't we just get all this material in discovery later on, and that's when we'll be able to build our case. Yes. Then you're running a real risk that you're not actually going to get to the point where the other side's ordered to provide those documents.
Yeah. Thank you, Bree. We could talk about this forever. It's such a big topic, testamentary capacity, and it keeps coming up. But thank you for your time. So that's today's spill. Thanks for sipping along with us on Wilson Spills. Join us next time for another cocktail, another case, and another story worth unpacking. Cheers, Bree.
Cheers. I've almost finished my cocktail.